Ms. Dean.
Thank you, Chairman Issa, Ranking Member Johnson, and of course to all of our witnesses today. Thank you for your expertise and for sharing this information. I'd like to go back. In a former life, I was a professor of writing at LaSalle University, and I really emphasized to my students the value of plain English. I can't even say it, plain English. So for the non-technical IP and technology folks out there, can we go back and tell us, what is a SEP? I'm laughing because you talked about SEPness. I never even heard of such a word, excuse me, for my ignorance. But could we go back for everyday Americans? What is a SEP? What are standard essential patents? And what's the criteria to become one? Maybe Mr. Copan? Dr. Copan?
Thank you so much for that question. And I appreciate the focus on clarity in writing and communication, and thank you for raising that. Patents provide innovators the ability to practice their invention in the marketplace and the ability to exclude others. In the case of SEPs, the inventor agrees to make that invention available to everyone who wants to practice a standard that would also be available then on fair, reasonable, and non-discriminatory terms. So it really is a commitment to make an invention broadly available to those interested in practicing.
Thank you. I appreciate that.
Ms. Dean,
I'm sorry. Yes, thank you, Mr. Baker.
I'm going to make this very simple. If you have a car and you take the tires off it, it doesn't work. Those tires are standards essential to the operation of the car. It's that simple. It's not a long definition. I was there when we wrote the policy guidelines. The language was simple, and it's currently being totally manipulated on what the original intent was by other people taking that simple language and trying to tell us what it means. I wrote the darn guidelines. I can tell you what it means.
That's very helpful. Anecdotes like that are very helpful to me. Mr. Cohen, we've heard arguments today, and I'm following up really on what Mr. Massey was talking about, that SEPs are so important to certain technologies that SEP holders should not be able to obtain injunctions or exclusion orders. But doesn't that run the risk of devaluing U.S. IP rights? Why shouldn't SEP holders have the same rights as other patent holders to enforce their IP in court?
I think Professor Cotter's given a brief explanation of why there's a different kind of balance with regard to SEPs. That is that a SEP could be abused to extort an exorbitant monopoly rate when it should be made available on fair, reasonable, and non-discriminatory terms. So in theory, if you violate that obligation in negotiation, maybe you should be deprived of the right to an injunction, but you should still be entitled to a robust royalty or whatever the appropriate royalty is. That's kind of the trade-off for inclusion of the SEP in what is more or less a public good, which is a standard. Now, having said that, that calculation, which was first expressed in a case in Europe called Huawei versus ZTE, can easily be abused. What constitutes good faith negotiations? How much do I have to disclose? What if the implementer delays and delays for years and years? If in a world such as China, where they insist on equality in rates, shouldn't I disadvantage the party who is delayed and delayed in coming to the table and negotiating? It shouldn't only be one-sided on the side of the inventor or the patent owner. You have to also look at the behavior of the implementer.
Do you have any comments on a bill that I'm a part of with Representative Moran, the Restore Act, which I think was talked about before I came into the hearing? I apologize for missing that. It would provide patent owners who have proved infringement in court the rebuttable presumption that they are entitled to an injunction to protect the patent. I believe in strong patent rights and strong IP rights. They are essential. Do you have an opinion on Restore?
Yeah, well, I can say that it severely disadvantages U.S. courts in the competitive battle to assert jurisdiction over FRAND disputes, to rarely have an injunction available when there is infringement, including when there is delay. And it particularly disadvantages those companies that may not be implementing, that may simply be engaged in licensing the patents. And we should keep in mind that the U.S. is the largest a licensor of technology in the world by a long shot, and a large part of those licensing agreements, particularly in markets like China, are to unrelated parties, so it's not General Electric to its subsidiary, it's a Qualcomm to a Oppo, or whatever the case may be. So this is really important for the innovative capacity of U.S. companies to derive the appropriate amount of revenue. So I believe that I support this proposal to go back or have a presumption of availability of injunctive relief.
I appreciate that. And Mr. Chairman, thank you. I yield back.
I thank the gentlelady. Now go to the gentleman from Maryland. And